Hi everyone, I'm Sarah George, Chittenden County State's Attorney. One thing I did not expect in a Democratic primary is the amount of misinformation about the facts and the law as it relates to public safety. So I decided to do these posts in order to educate people and talk to people about the really important issues facing us today. I'm calling these posts Get Curious with Sarah George. If you hear something or you see something from my opponent or others that sounds a little suspicious, or if it actually sounds reasonable but my opponent is saying that my office isn't doing it, get curious. Ask me, ask somebody else, especially people who practice criminal court in Chittenden County. The most recent statement by my opponent was about a man who was arrested in Burlington after allegedly stealing cars. The statement was that this individual was not given appropriate conditions of release by the court or the state's attorney. Specifically, talking about a curfew and a responsible adult condition. So the first episode of Get Curious with Sarah George is going to be about conditions of release. The first and most important fact is this: state's attorneys don't impose conditions of release. Conditions of release in cases are imposed entirely, 100% by a judge. The state's attorney's office can certainly request conditions, and the defense attorneys can argue against them, or they can suggest alternatives. But under no circumstances in any case is it up to a state's attorney what conditions of release are imposed. So if a state's attorney or if somebody running for state's attorney tells you that they would give someone different conditions of release when charged with a crime, they are misinforming you about the law. Now, if a judge decides that conditions of release are appropriate, it's up to them to impose the conditions that are the least restrictive to mitigate that person's risk of flight from prosecution. That's the law. It has to be the least restrictive means. So in this case, again, my opponent made a statement that he would have imposed a curfew condition. So aside from the fact that he doesn't actually have the authority to do that, or he wouldn't have that authority, it's also important to note that a lot of the folks in our community right now who are stealing cars don't have homes. So a curfew, where? How would that impact this person's ability to come to court? The other condition of release that my opponent said he would have imposed is a responsible adult condition, which is essentially the court's ability to release somebody into the custody of someone else, again, to mitigate their risk of flight. The problem is that in this case, a responsible adult condition is prohibited by our law. Vermont law only allows the imposition of a responsible adult condition in listed violent offenses. The theft of cars, or statutorily is called operation of a motor vehicle without owner's consent, is not a listed violent offense. So the condition that my opponent said he would impose of a responsible adult, in this case, whether a misdemeanor or a felony, would have been illegal. Facts matter, friends. It is far too easy these days to spread misinformation, and we should be especially cognizant of people running for office that are doing it. If somebody is running for state's attorney, myself included, they cannot be wrong on the law and cannot spread that misinformation in the community. So, get curious, ask questions, stand up for the truth, and make sure that people running for office are giving you information and facts rather than misinformation and fear-mongering. Thank you for listening. Please share with any friends and tag friends that you think might care about the criminal legal system in Vermont and Chittenden County. Let me know what you want to talk about. Let me know what you're curious about. We could talk about bail. We could talk about harm reduction. We could talk about domestic violence or gun violence. Anything that you're curious about. Until next time, on Get Curious with Sarah George.